Let's roll, nerds.
On bond for an assault of a family member
Yes, sir.
since 2023.
Yes, sir.
In 2025, in February, you pick up a terroristic threat,
Yes, sir.
and now you've picked up another assault of a family member and a violation of a protective order. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
Yes.
You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 16th, 2025, in Harris County, Texas, officer was dispatched to an apartment for a family assault. Officer met with the complaining witness. The complaining witness had visible injuries on her face, including bruising on her eye and swelling on her head. The complaining witness went over to the defendant's house. Defendant grabbed the complaining witness by the arms and threw her into a table and chairs. Defendant began to punch the complaining witness multiple times in the stomach and slap her in the face. Complaining witness attempted to leave, but the defendant followed her through the apartment complex. The defendant currently has a protective order for terrorist threat, which bars contact between the complainant and the defendant.
In Harris County, Texas, the defendant faces serious charges after multiple incidents involving assault and violation of a protective order. In a recent court hearing, the defendant, who has a history of criminal behavior, is dealing with 3 separate cases: an assault on a family member, AFM, in 2023.
Is that the violation of the protective order?
Yeah, it's a felony, VPO.
Your Honor, may I be heard? Your Honor, the complaining witness shows up at my client's apartment. He lives there by himself. She shows up like at 5 a.m. in the morning. My client did not assault her in any way. Actually, the complaining witness broke his phone, and my client left the apartment so he wouldn't have to deal with her because she wouldn't go away. But at no time, Your Honor, did he assault her. I did get to check out
A terroristic threat charge in February 2025, and a new assault on a family member and violation of a protective order in May 2025. The prosecutor argued that the defendant's pattern of violent behavior across different victims, 2 separate individuals, warrants a higher bond and potential bond revocation.
the videos, Your Honor, where the officers are interviewing the complaining witness. She alleges that he punched her in the abdomen. She is in absolutely no distress, Your Honor, when she's talking to the responding deputies. If he had punched her in the abdomen, Your Honor, I can really say that she probably would be doubled over and would want to go to the hospital. The EMS did check her out, it appears, but she refused transport to the hospital. I couldn't tell from the body-worn cam video, Judge. It wasn't close up enough, but I couldn't tell. I couldn't see any bruises or.
The defense lawyer contended that the defendant had not assaulted the complainant, arguing that the woman had broken the defendant's phone and initiated contact with him at his apartment. Additionally, the defense pointed out that the complainant appeared calm and had no visible distress or bruising when interviewed by officers.
And it's like I said, she was not in distress whatsoever. She is the one who really went to his apartment. He did not go, he did not violate the protective order. And
Well, the violation of protective order is a felony offense anyways, so.
yes, Judge, I understand. I understand.
So I just
And-
have, an assault, a terroristic threat, and now another assault.
Right.
So which assault is he alleging that's the,
Right, Judge.
right?
Yes, Judge. And she's filed or the state has filed a terroristic threat on her behalf, a charge on her behalf.
The prosecutor countered that the protective order, which was put in place due to previous charges, prohibited any contact between the defendant and the complainant. The prosecutor also argued that the complainant's visible injuries, including bruising and swelling on her face, were sufficient to support the allegations of assault.
If she was so terrified of him, Judge, why is she popping up at his
I don't know
apartment?
that that's actually true. Who's saying, he's just telling that to you? I mean, how do we know that's really true?
Well, she's there, Judge. Those are the apartments that are shown on the body-worn cam video. It's his residence.
Is she actually on video at his apartment? Have you
They're
seen
outside
it?
of the apartment. They're outside on FM 1960. That is not her residence. The protective order has got a totally different address where he is prohibited from
Tell me, Sebastian.
going.
Okay, well, the VPO is not based on an address restriction, it's based on the assault of a protected person. And as far as the representations that
The defendant's continued involvement in multiple violent situations with different people, including the violation of a protective order, suggested a dangerous pattern of behavior. The prosecutor urged the court to raise the bond to $20,000 across all three cases. Emphasizing the seriousness of the charges,
defense has made today, we have no way of verifying any of that to be true. I disagree with the assertion that she shows no visible injuries. Her face does appear to be swollen with some red markings. Or three, the allegation that she's over at the house don't disqualify her as being a protected individual, and BPO is for an assault, not for a residency restriction. And at the end of the day, all those are fact issues, and what we're left with right now is the fact that in 2023, with a separate victim, he has an AFM, he bond forfeits, then we have a terroristic threat with someone else, and now he picks up a separate AFM. And we can talk about how she's back all the time, but I think that ignores, first of all, the realities of domestic violence situations. And second of all, this isn't just one person that he's having multiple problems with. These are two separate.
and the defendant's apparent inability to change his behavior. In response, the defense emphasized the lack of concrete evidence proving the defendant's involvement in the assault, including the absence of any distress or visible injuries on the complainant during the police interview.
People. So the state is going to stand on its motion to revoke and raise bail and is going to ask for 20,000 on all three cases.
Your Honor, may I respond? The complaining witness has not, has recanted to these March 16th, to the current charges, to the newer charges.
Which alleged victim is recanting, the first or the second?
The terroristic threat complaining witness, Your Honor. And the other assault family member case, Judge, the complaining witness is currently incarcerated.
The defense also pointed out that the complainant had recanted her statements regarding the terroristic threat charge, suggesting that the defendant's version of events might hold more weight. Despite the defense's claims, the judge was not swayed by the arguments, noting the ongoing pattern of criminal behavior and the defendant's prior history of bond forfeiture and violent conduct.
But
So which one's
The oldest one was in jail.
and
Or
No, I'm not sure, actually. I have a colleague who spoke to her. I forget exactly what she's in for. She is in jail. As far as her recanting, I mean, that's,
is she in jail for something against him?
no, I don't think so.
And also, Judge, the complaining witness, the one that the protective order is on behalf of, she has not given a rip on the terroristic threat case, Judge. So something's not right. She doesn't want to.
Problem is
Tell the truth.
he keeps
The judge expressed concern over the defendant's disregard for legal orders, especially the protective order in place, and the potential danger his continued actions pose to the community. The judge ultimately revoked the defendant's bond, setting a new bond amount of $10,000 for the first assault case, $5,000 for the terroristic threat, and left the new assault case's bond unchanged.
picking up cases. Stuff keeps happening to him. It's just, I mean, I fall down and I pick up a new case.
Yes, Judge, and I did want
Are we supposed to just let him go because he's picked up now a felony? You
I
know,
just wanted to relate to you, Your Honor, that my client does not have funds. He paid to get out with his income tax return, Your Honor. He paid to get out on these two new charges. He paid to get his car because he was not arrested at the scene, but he was arrested thereafter while he was driving. They impounded his car. He paid to get his car out.
The judge emphasized that consequences for repeated offenses had to be enforced, explaining that continued criminal behavior without consequence undermines the integrity of the judicial system. The defendant was warned that if he violated any further orders of protection, the court would hold hearings to potentially set his bond at zero, ensuring that the safety of the community was prioritized above all else.
He paid because to get a new phone or get his phone repaired because complaining witness broke his phone. on the date of the alleged incident. And, and I'm asking the court to leave his bond as is, or in the alternative, Judge,
In closing, the judge stressed that the defendant's actions had escalated over time, and the court needed to take firm action to prevent further harm. In conclusion, the defendant is now facing multiple criminal charges in Harris County, including assault, terroristic threat, and violation of a protective order. The court took a tough stance, revoking his bond and raising the bond amounts to reflect the seriousness of his actions. Despite the defense's arguments, the judge emphasized the importance of holding individuals accountable for their behavior, particularly when they pose a threat to others. The case underscores the challenges that the criminal justice system faces in dealing with repeat offenders and the need to impose consequences that reflect the severity of their actions. The defendant's future in the court system will depend on whether he adheres to the court's protective orders and whether he can avoid further violent incidents.
If they email you, you don't reply. But at some point, we have to say when. Now's that time. Because of you.
is your,
I'm not going to set it that high. I think that high is obtuse, and that's just, mean-spirited to go that high. But
I don't know, Judge, this is 2 years worth of history here. Two different people.
that's why they set the felony bond at 30,000. But I mean,
You gave the first victim 10 stitches in the head.
10 stitches in the head.
I read that, Judge.
Tell me about the second one. What happened with the second one?
The second one is this one, and then you want
All
to.
right. How bad are we talking injuries on the second?
Judge, it's swelling and then bruising in the head.
All right, so I'm going to do 10,002 on the first one, 5,000, so 10,003 on the first assault, 5,003 on the terroristic threat, and then I'll leave the second one as is. The new one as is.
Thank you, Judge.
No.